I've lived on this farm for nearly 3 decades, long before there was a single cul-de-sac or community mailbox within 10 miles of my fence line. My grandfather passed this land down to me, and I've kept it running as a small-scale but profitable operation: cattle, soybeans, and seasonal hay. I've always been on good terms with the county and even the state agricultural board, keeping my records clean and my land well managed. A few years ago, a sprawling suburban development popped up next to the southern edge of my property, complete with cookie-cutter homes, white fences, and a newly formed HOA that quickly got a reputation for being, let's say, overzealous. At first, I didn't mind them. People gotta live somewhere, right? But then came the noise complaints, then the letters demanding I remove my barn because it obstructed the aesthetic of their sunset views. Then came the fines for agricultural odor, even though I wasn't part of their jurisdiction. I ignored them, of course, until one day a bulldozer rolled across my southern pasture and started leveling earth. I thought it was a mistake. It had to be. But when I confronted the site supervisor, he smugly handed me a contract, signed not by me, but by someone from the HOA, claiming the land had been repurposed for light industrial development. I was stunned. Apparently, the HOA believed they had somehow annexed part of my land after a boundary discrepancy, based on some outdated, unofficial map they dug up from the county archives. No letter, no buyout offer, no discussion, just fences, machines, and concrete pouring where my cattle graze. They weren't building a clubhouse or a parking lot either. They were erecting a $25 million production facility for what they claimed was a community enrichment partnership with a private plastics firm. And here's the kicker: they thought they could do it because the county had recently updated zoning laws in a way that gave more power to local associations to manage adjacent property in cooperation with municipal recommendations. They were wrong, dead wrong, because I hadn't just inherited farmland. I had inherited mineral rights, water rights, and a protected historical designation tied to my family's ownership dating back to the 1800s. Not only did the land have federal recognition, but any disturbance without express written consent was a violation of multiple state and federal land use statutes. The HOA didn't know this because they never bothered to pull the full deed history. They just skimmed the tax maps and assumed it was fair game. What's worse, the company they partnered with began moving hazardous materials in without a single environmental review. I kept quiet at first, documenting everything: every truck, every piece of equipment, every violation. I even installed new trail cams and a drone surveillance system to log activity 24/7. When I finally contacted the county clerk, she was horrified and confirmed there had been no permit filed for industrial development on any part of my property. That's when I realized this wasn't just arrogant, it was outright theft. But instead of going straight to court, I hired a property rights attorney who specialized in land seizure cases. Together, we began building a case so airtight it would not only crush the HOA legally, but also expose every single illegal deal behind the factory's construction. And while they continued patting themselves on the back, completely unaware of what they triggered, I was getting ready to spring the biggest legal trap they'd ever walk into. Every inch of this farm was about to become the most expensive mistake they'd ever made, and they didn't even know it yet. The first move in my legal trap was patience. Painfully precise patience. I knew that reacting too early would tip them off and give them time to cover their tracks, so instead I let them build. They kept expanding the factory site deeper into my land, pouring more concrete, installing underground piping, even running electrical lines straight through the old oak grove my grandfather planted in 1947. Every single inch they disturbed was another nail in their own coffin. Meanwhile, my attorney filed quiet inquiries with the state's land management office, confirming the protected status of the entire southern quadrant. The HOA hadn't just overstepped, they'd bulldozed into a legally preserved agricultural easement and part of a historical trust. My lawyer's team dug into public records and unearthed something even more damning. The HOA's annexation vote wasn't valid. They claimed to have passed a resolution at their annual meeting giving them limited rights to manage bordering land. That meeting never had quorum. Even worse, the minutes were doctored. Several signatures belonged to people who had moved out of the neighborhood years before. That alone was grounds for civil fraud. But I didn't stop there. I paid for an independent environmental assessment and found contamination already beginning from improper storage of solvent near a runoff line that emptied into my pond. That pond feeds into a stream that runs through a protected wildlife corridor, meaning federal regulations had already been broken. We submitted the findings quietly to the Environmental Protection Agency, who opened an investigation under the radar while I kept filming timestamp footage, every work crew and shipment arriving on my property. By the time the HOA finally held their ribbon-cutting ceremony, complete with champagne and local press coverage, I had a 300-page legal file ready to be served. My lawyer called it the atomic bomb of cease and desist packages, but I still didn't launch it yet because just days before the opening, I uncovered something that changed the entire nature of the case. The HOA president had received a personal payment from the plastics company in exchange for expedited cooperation. A $120,000 deposit had been wired into his personal LLC, conveniently just 2 weeks before they broke ground on my property. That was no longer just trespassing or fraud. That was corporate bribery and racketeering. With this new evidence, we went directly to the state attorney general's office, who opened a criminal investigation and advised us to hold our civil suit until the state case was fully underway. Now, not only were we building the civil claim of the year, but we had law enforcement backing us up. Still, I waited. The longer they operated, the more damages they incurred. Every additional day of unauthorized use was a multiplier of penalties, of liability, and of humiliation. My neighbors still believed the HOA had done something brilliant, converting unused farmland into a lucrative community asset. They had no clue that every cheer they gave at that ribbon cutting was just another rope tightening around the HOA's neck. I knew they were watching me too. I'd seen a few board members drive past, probably wondering why I hadn't caused a scene. But that was the thing. Scenes are loud, legal traps are silent, and mine was almost ready to snap shut. The moment finally came on a Wednesday morning when the first cease and desist order was delivered to the HOA office by a process server and 2 uniformed deputies. I had timed it perfectly, just as a local news station was doing a follow-up piece on the factory's positive economic impact. Cameras were rolling when the HOA president opened the envelope and his face turned from smug to sheet white. Simultaneously, my attorney filed for a temporary injunction, immediately halting all operations on the site. The plastics company, blindsided, had no idea the land they'd built on was under dispute. Within an hour, they received a second notice, this one from the EPA, citing multiple environmental violations, including the illegal discharge of industrial byproduct into federally protected waterway. And then came the third hit, a formal notice from the state's Historical Preservation Office, alerting them that they had desecrated a registered heritage site without review or approval. 3 government agencies in one day, and the icing on the cake was that every piece of it was triggered by their own hubris. The HOA scrambled, trying to organize emergency meetings and PR spin, but the more they fought back, the deeper they buried themselves. Their hired legal team argued that the land had been functionally abandoned, but my 28 years of property tax record and current livestock registrations obliterated that lie in minutes. Photos of my cattle standing feet from bulldozers were published online. Local news turned quickly. The hero HOA narrative collapsed under the weight of fact, and neighbors began turning on them as well, especially when it came out that association fees had secretly funded the initial survey and land clearing. My legal team filed a civil suit for unlawful land seizure, environmental destruction, damages to agricultural production, and intentional infliction of emotional distress. But what made the case explode was the financial audit of the HOA's dealings. That $120,000 deposit wasn't a one-time deal. It was the tip of an iceberg. There were 6-figure payments to 3 other board members, masked as consulting fees, all paid out by the plastics company over the course of 6 months. That escalated the case into criminal territory. The state issued subpoenas and a grand jury was convened. Suddenly, this was no longer just a personal land dispute. It was a full-blown public corruption scandal. Former board members began flipping to avoid charges, revealing internal emails, meeting recordings, and memos that made it crystal clear they all knew the land wasn't theirs. One even admitted in sworn testimony that they expected me to cave or settle quietly. They had no idea I'd prepared for war. The factory shut down operations within 72 hours. The CEO of the plastics firm issued a public statement blaming miscommunication with local partners, but behind the scenes, their legal counsel was begging for settlement terms. I didn't give them any. I wanted a courtroom. I wanted precedent. And more than anything, I wanted them to feel the full weight of every arrogant decision they'd made. As the criminal charges began stacking up, the HOA collapsed under its own corruption. Board members resigned, lawyers withdrew, and suddenly the once proud neighborhood coalition was reduced to a fractured group of angry homeowners demanding refunds and resignation. And I wasn't done yet. With the factory shut down and the criminal investigations underway, I shifted my focus to the cleanup, both literal and legal. My land was no longer just damaged, it was tainted, both in the environmental sense and in the emotional one. The southern pasture, once filled with grazing cattle and wildflowers, now looked like a construction war zone. Concrete slabs, torn up soil, drainage pipes sticking out of the ground like broken limbs. I brought in environmental consultants to assess the full extent of the damage, and their findings were worse than expected. Chemical residue from improperly stored barrels had already seeped 3 feet into the soil and was threatening the aquifer beneath my land. That aquifer water didn't just serve my property, it fed water to 2 nearby farms and a wildlife habitat. Suddenly, what the HOA had done wasn't just illegal, it was catastrophic. We filed an emergency motion in court to compel the plastics company to fund a full environmental remediation project, estimated at nearly $3.2 million. The judge granted it, and within days, hazmat crews were crawling all over the site under court order. But while they were cleaning up the mess, I was gathering more ammunition. My attorney and I filed motions to subpoena every document the HOA had ever touched, from emails to budget records to board meeting transcripts. What we uncovered next was a trail of incompetence and deceit that would have made any prosecutor salivate. Not only had the board misused association dues to fund illegal activity, but they'd also used HOA credit cards for personal expenses, vacations, electronics, even a hot tub purchased for board morale. Homeowners were furious. Class action suits began to form within the neighborhood, and suddenly I wasn't fighting alone anymore. People who once complained about my cows were now knocking on my door, asking how to sue the board for embezzlement and fraud. I shared my legal team's contact info without hesitation. The case went from local scandal to state headline in a matter of weeks. Reporters camped out by the factory ruin. One former board member fled the state entirely after being named in a second round of criminal charges. Meanwhile, I kept pushing forward. My own lawsuit now included claims for punitive damages, which, because of premeditated nature of the land theft, could easily multiply the total payout by millions. My lawyer estimated we were looking at a potential $12 to $15 million judgment. But I didn't just want money. I wanted public accountability. I wanted the court records to show forever that this land was never for sale, that the people who tried to steal it didn't just lose, they were buried. In a twist of irony, plastics company, desperate to avoid further liability, offered to fund an agricultural education center on my land as part of their public restitution campaign. I declined. This wasn't a branding opportunity for them. This was justice. For the first time in months, the concrete was torn up and hauled away by the very company that had laid it. I stood on the southern hill of my property, breathed in the scent of fresh soil, and knew we were just getting started. While the legal cases continued grinding through the courts, I turned my attention to something the HOA and the plastics company had completely underestimated: public narrative. They had tried to spin this as a visionary project hijacked by a disgruntled farmer, but the truth had already taken root in the media. I was no longer a lone landowner. I had become a symbol. Local schools invited me to speak about land rights. Agricultural journals published features on how to protect historical designations. One article titled me "The Man Who Outsmarted a $25 million Machine," and I'll admit I framed that one. With the attention came leverage. Several nonprofit organizations reached out, offering assistance in transforming the damaged portions of my land into educational preserves, complete with grants for ecological restoration. Meanwhile, the HOA's former president was now facing not only fraud and racketeering charges, but also potential jail time for perjury during initial deposition. His assets were frozen, his reputation in ruin. I watched the neighborhood implode. Homeowners held emergency meetings in church basements because no one trusted the community center anymore. Lawsuits flew in every direction, against the board, against the company, even against the original surveying firm that signed off on the bogus annexation. My favorite moment came when a homeowner stood up at a local town hall and demanded to know how an unbothered rancher had managed to dismantle their entire governing body. I told them it wasn't about being unbothered, it was about being underestimated, and I wasn't done. I began working with my attorney on a proposal to push legislation that would close the very zoning loophole the HOA had tried to exploit. We drafted what would later be dubbed the Farmland Integrity Act, a bill that would prevent HOAs from annexing, leasing, or repurposing land without fully verified deeds and triple agency review. When we presented it to the state legislature, it already had bipartisan support because no one, regardless of politics, wanted to be on the side of a land thief. News spread further than I expected. National outlets picked up the story. A documentary crew showed up. I declined the first 3 interviews, but agreed to one with a network that let me walk them through the property, showing the difference between untouched land and the wreckage the factory had left behind. Standing among the broken slabs and rebar, I told them what my grandfather once told me: land is memory. You don't sell memory, you protect it. It became the most quoted line of the segment. Donations poured into the Wildlife Trust that helped assess the factory's environmental damage, and by now, even the plastics company was bending over backwards to settle. They offered a massive settlement package, nearly $18 million in damages, cleanup, and community contributions if I dropped the civil trial. I refused. I wanted the trial. I wanted every transcript to be public. I wanted school kids 50 years from now to study this case and know what happens when greed meets legacy. And deep down, I think they finally understood that I wasn't after money, I was after an example, and I was going to make sure they pay me. The trial began 6 months after the cease and desist orders were issued, and by then, the courtroom was packed with reporters, community members, environmental activists, and even law students eager to witness what had become one of the most high-profile property rights cases in state history. The plastics company came in with a fleet of attorneys trying to paint themselves as innocent third parties misled by a rogue HOA. The judge didn't buy it. From the first day of testimony, it was clear they had failed every basic standard of due diligence. They'd ignored property records, dismissed legal notices, and bypassed environmental assessments, all in pursuit of a fast-track development deal they thought no one would challenge. But I challenged it. I took the stand and laid out everything, from the moment the bulldozers crossed my fence line to the day hazmat crews tore up their meth. I showed photos, videos, maps, and letters, all meticulously documented. My voice didn't shake. I wasn't angry. I was focused. I told the court how they tried to erase my legacy without so much as a phone call, how they saw an empty field instead of a family story, and when my attorney played a drone video showing cattle circling around massive machinery, even the judge looked visibly disturbed. Over the next several days, former board members testified under subpoena, each one confirming the fraud, the bribes, the cover-ups. The HOA's former treasurer admitted they never intended to inform me, just to push forward and let the court sort it out if it became an issue. That statement alone became a turning point. The jury deliberated for less than 48 hours. Their verdict: a sweeping victory on all counts. The court awarded me $14.6 million in damages, plus an additional $4 million in punitive damages, enough to bankrupt the HOA and put serious dents in the plastics company's future plan. But that wasn't the real win. The real win was the ruling itself. The judge issued a permanent injunction barring any future development on my land without my explicit consent and reinforced the historical protections already in place. Set legal precedent statewide. HOAs could no longer claim power over adjacent land without verified ownership and full consent. Within weeks, similar cases around the state were reopened, property owners citing mine as justification. I became a reluctant figurehead, but I used the momentum wisely. I helped draft clearer zoning laws. I co-founded a nonprofit that provided legal support for rural landowners, and I went back to farming. I rebuilt the southern pasture. I planted a line of white oaks where the foundation used to be. They'll take decades to grow. That's the thing about land. It's not about what it gives you now, but what it holds for later. Factories' ruins are gone. The lawsuits are closed. The story isn't forgotten. And whenever someone asks me how I took down a $25 million illegal factory without firing a single shot, I just smile and tell them I didn't need to fight. I just stood my ground and let the truth do the pushing.